And now it's time for another case law update. Today's case is ConocoPhillips Company versus Kenneth Hahn, a recent ruling by the Texas Supreme Court that provides a critical guidance on whether a non-participating royalty interest, originally fixed, can later be converted into a floating royalty. This case has been winding its way through the courts since 2016, and it raises some big questions about NPRI interpretation, lease ratifications, and the enforceability of stipulations of interest. Here's the background. Kenneth Hahn originally owned 37.07 acres in DeWitt County, Texas, with a quarter mineral interest under the land. In 2002, he conveyed the land to William and Lucille Gibbs, but reserved a 1/8 NPRI for 15 years. In 2010, the Gibbses leased the land to Burlington Resources, a subsidiary of ConocoPhillips, under a quarter royalty lease, which required ratification from all royalty holders in order for Conoco to pool the acreage. Hahn ratified the lease in 2011 and later signed a stipulation of interest stating that his reserved interest was 1/8 of royalty for 15 years. ConocoPhillips pooled the acreage into the Maurer Unit B and initially credited Hahn with a fixed 1/8 NPRI. However, the company later claimed that this was incorrect, arguing that under the stipulation, Hahn's NPRI was actually 1/8 of the 1/4 landowner's royalty, or 1/32 of production. But we know from all these fixed versus floating royalty cases that a 1/8 NPRI is a fixed royalty at 1/8 of production, but 1/8 of royalty would vary depending on the lease terms and make it a floating royalty. Hahn sued, seeking a declaratory judgment that his NPRI remained fixed at 1/8 of production. The Texas Supreme Court tackled the two documents that Hahn signed. First, the ratification of the lease. Did Hahn's ratification of the original lease alter his NPRI? The court ruled that it did not. The court addressed the particularities of NPRIs in that they are non-possessory and distinct from other types of royalties. Specifically, a fixed NPRI represents a set share of production and cannot be diminished by lease terms unless explicitly stated. While Hahn's ratification bound him to the lease's pooling provision, it did not subject him or his NPRI to the lease's royalty rate. Second, the court addressed the stipulation of interest. Unlike the ratification, the court found that this document effectively converted Hahn's NPRI from fixed to floating. The court stated that the stipulation of interest clarified the parties' intent and contained conveyance language to modify Hahn's interest. Relying on its 2021 decision in Contra Resources versus Ellison, the court emphasized that such agreements are enforceable even if there's no pre-existing ambiguity, as long as the document is properly executed and supported by consideration. In short, the stipulation of interest was an enforceable agreement whereby Hahn converted his fixed royalty interest into a floating royalty interest. So why does this case matter? Well, this ruling should garner particular excitement among title practitioners, as this ruling confirms that a stipulation of interest is an effective curative tool to establish mineral title, regardless of whether the underlying instrument is ambiguous. But by that same token, any type of royalty holders should be paying careful attention when executing a stipulation of interest, given that they could end up changing the value of their interest. Well, that's it for today. I'd like to once again thank Miguel Otero for his help on this update. Thanks for listening, and we'll see you next time.